Hey everyone, it's Rob Ryder. January 18th, 2014. It would be a Saturday in the evening. And I need to get this video done and out because I want to move on to some really great stuff that well, this would be great too, but great stuff that's turned up here in the last couple days, having to do with claiming your citizenship in the city. And something that we haven't done, and how the CAFR funds work, and how when you really start to read these CAFR reports, you see that all these agencies have all this liquid asset money at hand, and in the report it says what it would take to pay off all the debts, and you see all this money they would have left, and you wonder, well, why aren't they paying off the debts? Well, that's something I pointed out before, because only registered electors can vote to tell the treasurer to pay the debts. And we are not registered electors. As soon as we are, we can tell them to pay the debts. More on that later. But this is going back to the court administrator and how we're going to use the court administrator. And so contempt of court and other actions using the court administrator. Again, I did a video. Last video I did was specifically on the court administrator, and I wish, if you haven't seen that one, you would go watch that. I would say the easiest thing for you to do is to search by the word court administrator within my channel, or just do it by upload date, and it was the one just prior to this, sometime in January, last Sunday I believe. Anyways, here's an example. Fictitious plaintiff: a person appearing in a writ, complaint, or record as the plaintiff in a suit, but who in reality does not exist, or who is ignorant of the suit and the use of his name in it. It is a contempt of court to sue in the name of a fictitious party. Black's Law, 5th edition, fictitious plaintiff. So it's contempt of court if the person doesn't exist, and again, this could be a fictitious person, but they have to exist. They have to have a certificate of existence, or a certificate of incorporation, or a certificate of good standing, or whatever the proper term is. And as we'll see, when you look at the name of the bank in a foreclosure as the plaintiff, we think it's the bank. It really isn't the bank. In fact, it's nowhere near being the correct name of the bank. And if you were to take the name of the plaintiff and go to the Secretary of State and try to get a certificate of good standing, which every corporation doing business in the state is supposed to have, you're not going to find one. Well, when you don't find one, you tell the Secretary of State, well, then send me a certificate that says there isn't one, please. Thank you very much. There's your evidence that you have a fictitious plaintiff and contempt of court. And if you don't know already, this is Rob Ryder. My email address is courtofrecord@aol.com, and my phone number is 616-712-6179. And if you can donate, the PayPal account name is ashleyritlewski@gmail.com. That is the PayPal account. Or snail mail to Robert Ritlewski, 10955 14 Mile Road, Rockford, Michigan, 49341. That's the address for today. Stuff will be covered in the next one. What's the difference between a physical address and a business address and post office address? And there's a few more there. There's all sorts of addresses. You need to pay attention to which one we're working with. Okay, so before we get to the contempt of court part, I had gotten a phone call late on Friday from a brother named Xavier, who's really only been looking at this kind of stuff for the last couple of months, because unlike other people that have been looking for quite some time, he doesn't have any problems. He's a plumber, does okay, but he sees lots of empty houses when he goes by, and he's paid attention to why that is, and he understands the banking thing, and he also understands there's lots of people looking for houses, and he's just trying to figure out, well, is there something he can do, maybe make a buck. And we had a nice conversation. I said, well, that's what you could do, and more power to you, but I'm more interested in gaining the control of my signature, and then I don't need anybody's money. If I need something, I just sign my name. That has more to do with the registered elector stuff. But as we were talking, I said, well, do you know what a lis pendens is? And he said, yeah, I do. And, a lis pendens is well, he's heard of one. I said, okay, well, that's a notice that there's a suit pending. But it's not the suit, it's just a notice. So the question is, where's the suit? But before we get there, let's just see what lis pendens is. It's Latin for suit pending. Duh. This may refer to any pending lawsuit or a specific situation in the public notice of litigation, that has been recorded in the same location where the title of real property has been recorded. The title of real property. So, this may refer to any pending lawsuit or to a specific situation with a public notice of litigation that has been recorded in the same location where the title of real property has been recorded. Well, what has been recorded there? The notice or the lawsuit? I say it's the lawsuit has been recorded where the title of real property is located. It's in the title office, right? It's not in the register of deeds, as we'll see in a second. Or it's in the office of the recorder, wherever the titles are kept, right? Now, a lot of places that use the Torrens system, they have a thing called a certificate of title. Other places that don't use the Torrens registry system have things called abstracts of title. At the end of the day, it's pretty much the same piece of paper. And if you had fee simple ownership, you should have a copy that shows that you're the owner with your name on it. And you don't have one of those. Anyways, this notice, the lis pendens, secures a plaintiff's claim on the property so that the sale, mortgage, or encumbrances of the property will not diminish plaintiff's rights to the property should the plaintiff prevail in the case. In some jurisdictions, when the notice is properly recorded, lis pendens is considered constructive notice to the other litigants or other unrecorded or subordinate lien holders. The term is sometimes abbreviated as lis pend. In current practice, a lis pendens is a written notice that a lawsuit has been filed concerning real estate involving either the title to the property or the claimed ownership interest in it. The notice is usually filed in the county land records office. So, this just said the notice is in the land records office, and that's where you would find it here in Michigan. You go to the register of deeds, if that's where the land records are supposed to be. That's what they say. Because when you go online and look it up, it says you're going to look at the land records. Okay, well, that's where the notice was. But up here, it talked about where the title of real property. And real property and land are not the same thing. So, the lawsuit is recorded where the title of real property is. Recording a lis pendens against a piece of property alerts the potential purchaser or lender that the property title is in question, which makes the property less attractive to a buyer or lender. After the notice is filed, anyone who nevertheless purchases the land or property described in the notice takes subject to the ultimate decision of the lawsuit. Okay, the lawsuit that's been recorded where the title to the real property is. We need to find that office. The recording office will record the lis pendens upon a request of anyone who claims to be entitled to do so. For instance, because he has filed a lawsuit. All he needs to do is claim. Doesn't even have to prove it. Just claim that he is entitled to do it, and he can record it. If someone else with an interest in the property, like you, believes the lis pendens is not proper, he can then file suit to have it expunged. Well, where would he file the suit? Not where the notice is. It's just the notice. He would have to file the suit where the suit is, which is where the title to the real property is. I hope you see the difference. Some states' lis pendens statutes require the filer of the notice, in the event of a challenge to the notice, to establish that it has probable cause or good likelihood of success on the merits in this case in the underlying lawsuit, or states do not have, other states do not have such requirements. Okay. So, this lis pendens is because somebody has filed a lawsuit against you. And while we would think it's the court that we would normally walk into, like the 18th Circuit Court, or whatever it would be, where you would have your hearing, that's the administrative side of the court. It's not the judicial side, and the judicial side is where controversies are decided. So if they recorded it, it would be in the judicial side of the court. That 18th Judicial Circuit Court is not a judicial court. It's an administrative court. It's a court where they handle in rem jurisdiction about property, not in personam jurisdiction between two people who have a controversy. And this notice is a notice that there's a controversy between the plaintiff on a complaint, he would be the complainant, and the respondent on the complaint, who in the in rem side is going to be called the defendant. And we're looking for the piece of paper where, you'd be the respondent, not the defendant. Okay, so anyways, this is what the lis pendens is. So what I told Xavier was, well, look, see, this is the lis pendens, this is the notice, and what we're looking for is a thing called a certificate of pendency. Right? That we're looking for the suit. Now, he could understand that. Okay, yes, I'm looking for the suit. This isn't the suit, this is the notice. Where's the suit? I said, so you might call the court administrator at where he's at, they have circuit courts also, and ask their office where the certificate of pendency is for a particular lis pendens. And he said, okay, he said, I'm going to do that. So I'll get back to you and let you know what I find out. Could be a few days. He calls back an hour later. He says, hey, I talked to the office, to the court administrator. And I told her, kind of what I was looking for, that I was looking for the foreclosure file for a particular foreclosure. And she said, do you have the case number? He said, well, no, I don't, not right now. I said, well, when you do, then you would go to this website and put it in and find the court where the case was heard, and or where the case was filed, and then contact them to get a copy of the foreclosure file. He said, okay, well, I'm looking for the one of the things I'll be looking for is the certificate of pendency. And she said, yeah, that would be in there. He said, and basically what she said is you need to order the record from the court. So he's not talking to the court clerk. He's talking, actually is, the real court clerk, the judicial side court clerk, but called the court administrator, who's pretty much telling him, yeah, you would go to the court where the case was and order a copy of the record. So if you're in a foreclosure and you have a lis pendens, and if you don't know if you have a lis pendens, you would go look in your property file at the Register of Deeds or the county recorder or wherever the property file is, because they need to put a copy in there and get a copy of the lis pendens. And because you're in the county where it happened, because that's the county they're going to put it in, you would take that up to the trial court of wherever you're at. Here they're called circuit courts. Someplace it could be called a superior court, whatever. And take it to the court administrator and say, I'm looking for the certificate of pendency that goes to this lis pendens. This is a notice. I'd like to see the suit. Right? And see what they say. And just be on your A game. Okay, that's step one. You want to see what you want to get. You want to see what the record is. This is the side of the file that we're not seeing because we're going to the administrative side of the court where there is no controversy, instead of the judicial side of the court where the controversy is. That's where the pending suit is. And we never answered the suit, so eventually we're going to get a default judgment against us. I know it's all hokey doke and smoke and mirrors, but that's how they play the game. So, if you, so this is how they do it in This is how they do it in Ohio. Hang on a second here. Alright, there's that. And then I need where is that? Ohio's law. Okay. Close. Close. Cancel. Don't need that one right now. Alright, let's look at the form first. It's called a Form 73, Section 55 of something. Now, this is in Ohio. Clerk's certificate of pending suit for Liz pendants against registered land. It's a certificate for the pending suit. No suit can become notice to or in any way affect the owner of or persons interested in or persons dealing with registered lands until a certificate of the pendency thereof is filed with the recorder and by him entered as a memorial on the registered certificate of title. The registered certificates of title, that's Torrens' system, certificates of title covering such lands. It is not necessary to file a certificate for such pendency in cases where attachment has been levied and a certificate therefore duly filed with the recorder. Okay, nevertheless, this thing would say that I, somebody, clerk of whatever court, do hereby certify that on whatever day, in some case number, the case number was filed and is now pending in said court wherein somebody, the plaintiff, and somebody, the defendant, in which the plaintiff seeks whatever he seeks against the said whatever, as will more fully and at large appear at the pleadings and proceedings in the said case. Right? So this is like a synopsis of the fact that there's a case, and there has to be this certificate. The full name, county of residence, and post office address of each of the said plaintiffs is as follows, to wit: name, county of residence, P.O. address. Now again, what is the P.O.? Post office address is not the physical address of your house. It has nothing to do with your house number or street. It's a P.O. address. Either you have a post office box at the post office, or you're on a rural route and the rural route driver is the post office and your box is the post office box, but it can only be the post office box if it's properly labeled as a post office box. And they can't deliver mail that's mailed to a post office box unless there's a post office box. More of that later. I mean, this is one of the things that we're finding is the address is going to be very important, and the fact that you have registered as an elector within the smallest self-governing district, which appears to be a election precinct. So anyways, but back to this, witness in my hand. So this is something the clerk's doing. Okay, clerk, deputy. It's always interesting. The deputy is always after the clerk. Because really the deputy has the power, in my opinion, especially if it's the chief deputy. A clerk can have a disability, which is illegal. There's something legally wrong with them. They can't fulfill the functions of their office, like they didn't take the proper oath or whatever it might be, and they'll let them sit there in the office. But who's got the power? The deputy does. They get appointed by the judge because the clerk has a disability. They don't put another clerk in. They leave the clerk there with the disability, and then they get to appoint whoever they want. So you get these chief deputies that sit there forever, right? So, but the other thing, description of lands, the land which are affected by the filing of the within certificate in the office of the recorder of whatever county are situate in the county of whatever and the state of Ohio, and are described in registered certificates of title as follows. This is important. The certificate numbers, the registration book, the pages. The registered certificates of title. You should have a certificate of title in your possession with your name on it that says you are the titled owner of the property. I did videos on this, some time ago, explaining all this about the Torrens system. You don't have a certificate of title. And you may not have one because they don't use this system everywhere. Some places are certificates of title, others are abstracts of title. But either way, you should have it in your hand. It's the evidence that you're the owner. You don't have a certificate, shows that you're the owner. You have a warranty deed recorded in the land record that's being used as a implied trust, making you an implied trustee for somebody else, an unknown beneficiary, who put up the $10 where it says the grantor for $10 in hand paid and other valuable consideration, yada yada yada. Who gave him the $10? That's the bottom. Now this is where it get good. If you can see, because if you can get this certificate, this is what's going to happen. On here, it's going to say the amount of the lawsuit. I contend that this amount will not be more than $20, because if it was, your right to a jury would be preserved. You couldn't lose the property unless you had a jury trial. They couldn't take it in a hearing. You would have to have a jury trial. But see, they're not after the money. This has nothing to do with money anyways. This has to do with using a court of equity as an instrument of fraud against you to say, hey, that's my property. It doesn't matter what's inside the box. It's my box. I want the box. That's what this is about. I want the piece of paper. It's got my name on it. Right? And that's what they're contesting. Or in this case, they're saying you owe them $20 or whatever. You owe the $10 that somebody put up. It's never been paid. Right? So if you were to pay this amount, boom, the lawsuit would be over. So would the foreclosure. But this is going to, the other part of this is, when you find this is going to tell you where the registered certificates of title are for this property, and you want to have them get you a copy of that also, because it had better have your name on it. And as I remember, and you'll have to forgive me if I don't have this quite right, because this was, some months ago, but in these Torrens states, you would go to the register of title with your warranty deed to say, hey, I'm buying this property from this guy. I like to look at the title to see if there's any liens or encumbrances against it. And you would go and look at it and say, okay, everything is clear, because they're keeping track of everything on there. Yep, there's no liens or encumbrances listed on the owner's or on the original certificate of title. The original is kept at the title office, and then the owner is supposed to get a copy called the owner's certificate of title, which is an exact duplicate of what the original certificate of title is. But you want to look at the original in case this guy is showing you an older owner certificate. Of course, you've never seen his anyways, because he doesn't have it yet. My point is, you want to see the original in the file, and you go look at it. There's no encumbrances. Then you would surrender your warranty deed to the register of titles, who would then produce a new original certificate of title in your name and give you the owner's certificate of title for you to take with you. So you would have a certificate that said you're the owner. We ain't got that. So look at that. Doing this has nothing to do with putting any paperwork in, except to go, if you have a certificate of, a lis pendens, and that's kind of what a lis pendens looks like. In the Circuit Court of the 16th Judicial Circuit, Geneva, Kane County, Illinois, PNC Bank, National Association, which is a fictitious entity, you cannot find a certificate of good standing for PNC Bank, comma, National Association. Doesn't exist. The only thing I can think of that we haven't really looked at is to see if they have a DBA, a doing business as, within the county. But they don't have. This is supposed to be a bank, chartered bank, and a bank should have a certificate of good standing. If they don't, it's a fictitious plaintiff, and so boom, you could get them for contempt of court. So notice of foreclosure, right? This says it's a notice of foreclosure, a lis pendens. The thing about notices is the notice has to be attached to the instrument that it's a notice for. So where's the suit? It's not in here. The undersigned certifies the above entitled mortgage foreclosure action was filed December 31st. Yada yada. So somebody's certifying to this. Let's see who that is. Gives the names of the plaintiffs, the court in which the action is identified above. Okay, so this court here is where the suit should be found. In the Circuit Court of the 16th Judicial Circuit, Geneva, Kane County, Illinois. You take this lis pendens to that court administrator and say, I would like to see the suit that this is referencing. Name of the title holders, legal description, permanent land index, common address. See, common address. Now we got the common address. Well, that's the street. You know, you would think that's your mailing address. No, this is the common address. Identification of the mortgage sought to be foreclosed is as follows. Yada, yada, yada. Okay. So this was recorded in the, what do they use in Illinois? They have a recorder, Kane County, Illinois. Right? We have register of deeds here in Michigan. Some places have recorders. Okay? And this is a 4-page document. Now, one of the things they did was, this is the certificate of service. They didn't they didn't mail one of these or send one of these at all to Roe or her husband. It has nothing to do with them. They did send one to the Illinois Department of Finance and Professional Regulation, Division of Banking, and they also sent a copy, although it doesn't say it here, and I don't remember how we found out. I have to ask Roe again. But they sent a copy to City Hall of St. Charles, the city where the house is. But they didn't send her a copy. Or they did, but they used her P.O. box address, which we don't have. Or we don't have it on our house, or we don't have it properly, so we're not getting the mail. Because one of the things I was told by the post office is the post office gets your address from the zoning department at the county. We found out this week that the zoning department also has to do with the election districts or the election precincts. So, well, little details are starting to fit together. But this is a lis pendens, right? You find this in your land record, register of deeds, or recorders, or whatever it is, and you go get a copy of it. And I don't care if you've already lost your house and you're out of your house, go get a copy of it, take it up to the court in the Circuit Court of the 16th Judicial Circuit. Go find the court administrator's office and say, I want to see the frickin' suit. Basically, you want a copy of the record, right? We're talking about the whole record, but I'm talking about one piece of paper in the record, the suit that this notice goes to. But there's a whole record that you haven't seen. Now, again, if you haven't lost your house yet, and you find this thing here, and you go down and you pay this amount, whatever the amount is, the suit's over. You don't need to go to court. You just handle it before you got to court. And the person that can do all these kind of things, that has the juice to do it, is the Circuit Court Administrator in Michigan. But really, the administrator over the court where the action took place. Right, here's some of the duties, right? Primary case files, conducting court hearings, or preparing case files, right? So who knows where everything is that goes into a case? The administrator. Drafting court orders. They can also make up court orders. Prepares case files and conducts court hearings. Sounds a heck of a lot like a judge. And conferences with per parties. Per means proper person, which means me and you have a controversy. Not a in rem proceeding. That's over there in the administrative court. Per is when there's a controversy between two parties. Includes pretrials, final conferences, show cause hearings, which are subpoenas. Settlement conferences, facilitates the resolution of a case before trial, which would be, paying them this money right here that they wanted. Right? That's facilitating the resolution of the case before the trial. They can authorize bench warrants for criminal cases and authorize legal documents for judges with discretion. So they can issue writs, subpoenas, all sorts of stuff. All the things that a judge can do at chambers, I believe they can do, because we used to have people here called the Circuit Court Commissioner that could do everything a judge could do at chambers. at chambers. Which was everything except hear a case out in the courtroom. This is interesting. Errors could lead to extraordinary cost, major litigation, destruction of property, loss of funding, or failure of the agency to accomplish its mission, and may require the intervention of the judges or county's senior executives to resolve, or may not be resolvable. That would be treason. Back to the fleet. Get out the gallows. Yes, they have to make sure they do it exactly right. Okay, so a lot of this I'm going to be talking about for contempt of court comes out of this book here. It's the Contempt of Court Bench Book, 4th edition. If you went online and you just Googled Michigan Contempt of Court Bench Book, 4th edition, I'm sure it would show up. You're not from Michigan? Well, just see if you have one. Contempt of Court Bench Book, Contempt of Court, your state, whatever it says, but, you know, contempt of court's contempt of court. So let's see what contempt of court's all about. Oh, we didn't do this yet. Ohio law. This goes with kind of with this form here from Ohio, but let's see what the law says. No suit, action, or proceeding pending in any court affecting registered land or any interest therein or charge upon such land is lis pendens, notice of suit, to any person dealing with such land until a certificate of the pendency of such suit, bill, or proceeding under the hand and official seal of the clerk of the court in which it is pending is filed with the county recorder, and a memorial therefore entered by him upon the last registered certificate of title to the land to be affected. This section does not apply to the attachment or other proceedings in which official making an attachment, levy, yada yada yada, recording the certificate. Okay? So they're supposed to file one of these certificates of the pendency, and that's what this thing is called, if I'm not mistaken. Go back to the certificate of pending suit for lis pendens. Certificate of the pendency of such suit under the hand and seal of the clerk of the court in which it is pending. Right? So this is under the hand and seal of the court. Now if we go back and look at don't see, I'm not seeing anything to do with any court clerk on this paperwork. All right, there's nothing on that page. That's the attorney. That's the attorney. And that's the recorder. Clerk didn't touch this paperwork. Now again, I'm looking at paperwork for Illinois and reading a law from Ohio, but nevertheless, the paperwork they put into the recorder doesn't have anything on it. It was never seen by the clerk. So if it had been in Ohio, boom, they'd already be wrong. When any suit, bill, or proceeding has been dismissed or otherwise disposed of, or any judgment, decree, or order has been satisfied, released, reversed, or modified, or any levy of execution, attachment, or other process has been released, discharged, or other disposed, the sheriff or the clerk of the court in which the proceedings were pending. Now the sheriff isn't Tin Star. This is the English sheriff, in my opinion, probably the chief judge of the county, shall forthwith under his hand, and if the clerk under the seal of the court certify to and file with the recorder an instrument showing such discharge, release, dismissal, or final disposition. Okay, so when you go take care of it, the court is going to put in a piece of paper saying it's been resolved and go put it into the file. When such instrument is filed with him, the recorder shall enter a memorial, therefore, on the last registered certificate of title, opposite and under the memorial registering such suit, bill, proceeding, or charge. The cost of the same certificate memorial shall be taxed as other cost in the case. So, if you're in Ohio, you really want to find these people. You want to go through this because you want to find this registered certificate of title and make sure it's got your name on it. So, okay. Anyways, that's what the law read. But let's look at contempt of court. Because, again, one of the things is when we look at this foreclosure paperwork, right? Complaint for the foreclosure. This was for Rose that had the same PNC Bank National Association. Plaintiff is the same as did the Liz Pendants. And Rose checked with the Secretary of State, and they don't have a certificate of good standing. They don't have a certificate of existence. They don't show up. Well, I think when they tell you that, you would say, well, then I need you to send me something to that effect, that this PNC Bank Common National Association does not have a certificate of good standing with the Secretary of State, and I need it under your seal. Thank you very much. That's your evidence then that they're using a fictitious plaintiff. I still think we should check with the county, make sure they didn't do a DBA, but it's right that they don't exist. They sued in the name of a fictitious plaintiff. So you could go in and you could put in for a contempt of court, which I think we need to do because we want to smack these lawyers. If you get a contempt of court against the lawyer of record, who's an officer of the court, and he's always considered in court, and if he brings fraud in the court by saying he's supposed to know better, right? That's a fictitious entity. You can't be the lawyer of an organization that doesn't exist. You brought fraud in the court, brother. I'm sorry. 30 days in the brig. Then back to the fleet. So says Lord Coke. Lose their bar card. One last attorney to deal with. You're doing him a favor. Going to save a soul. It'll take him a while to understand that, but he'll thank you someday. So contempt of court explanation. So this is out of that book I was talking about. Close as many of these things as I can. They bother me. Okay. So jurisdiction of contempt proceedings. The court with jurisdiction of the proceeding during which the contempt occurred has jurisdiction of the contempt proceedings. If you're in a district court and that's where the contempt was, well, they need to go to the district court administrator. Circuit court administrator. Municipal court administrator. Whatever court you're in, wherever the proceeding is, if that's where the contempt is, because we're talking about something called indirect contempt, is really what we're going to be talking about. You take it to the court administrator of that court. A person may not be held in contempt of court for disobeying an order of the court in order the court was without jurisdiction to make. And go figure. Oh, by the way, definition of a court of record. Any court that can fine or imprison for contempt is a court of record. In case of indirect contempt, absent a sufficient affidavit, jurisdiction over the alleged contemptor does not attach. And this is the important one. In cases of indirect contempt, absent a sufficient affidavit, which means you put in an affidavit about the contempt, then jurisdiction over the alleged contemptor does not attach. The filing of an unverified affidavit is not jurisdictional defect. Therefore, it may be cured by amendment, which is swear to it later. Civil or criminal contempt. The distinction between refusing to do an act commanded, remedied by imprisonment until the party performs the remedial act, and doing an act forbidden, punished by imprisonment for definite term. So civil contempt is just refusing to do an act that you've been commanded to do, like turn over your books and records. Criminal is doing an act forbidden, like bringing fraud into the court. Right? That one's a crime, and the other one is coercion. In general, the sanctions of civil contempt are coercive and remedial in nature. The sanctions of criminal contempt are punitive in nature, intended to preserve the court's authority by punishing past misconduct through imposition of fixed sanction where there's no opportunity or need for the court to compel the contemptor's compliance with its orders. Right? We're going to get them to say, hey, there's already contempt in the court. I'm going to have you take judicial notice of the record that the plaintiff is a fictitious entity, fictitious plaintiff, doesn't exist. Here's the evidence. Boom, contempt of court. I'll tell you what, I'll be back in a minute. Okay, we're back. Should be. I hope everything is working. Two types of sanctions may be imposed in civil contempt. Coercive sanctions to force compliance, and compensatory sanctions to compensate the person injured. In criminal, the court may impose an unconditional and fixed jail sentence, a penal fine, or both. Under general contempt statutes, a jail sentence may be up to 93 days, and the fine may be up to $7,500. Willfulness is not a necessary element of civil contempt. Okay, so it doesn't have to be willfully done. Just the fact that they did it, it may have caused damage, is enough to give contempt. The essential element of criminal contempt is that the defendants acted willfully. Willfulness implies a deliberate or intended violation as distinguished from an accidental, inadvertent, or negligent violation. The standard of proof of civil contempt is unsettled. In some cases hold that proof of contentious conduct must be clear and unequivocal. In cases of criminal contempt, it must be proved beyond a reasonable doubt that the individual engaged in a willful disregard or disobedience of the authority or orders of the court. The primary interested party in a civil contempt proceeding is a person or persons being harmed by the contempt. The primary interested parties in a criminal contempt are first the court, in whose authority is being preserved, and second the public. Criminal contempt is a crime in the ordinary sense. It is a violation of law, a public wrong, which is punishable by fine or imprisonment or both. In civil contempt, the contemptor must be given an opportunity to purge himself of the contempt by complying with the conditions. Okay. Criminal, because the penalty is unconditional, fixed and imposed as punishment for past misconduct, the contemptor does not have the ability to purge himself or herself of the contempt. If you get it for criminal contempt, they're already guilty. Immediate view and presence. Direct contempt in court occurs during the court's sitting and in the court's immediate view and presence. When any contempt is committed in the immediate view and presence of the court may punish it summarily by fine, imprisonment, or both. Thus, when direct contempt occurs, the proceedings are often referred to as summary contempt proceedings. If it happens in the courtroom, in front of the judge's eyes, it's contempt, it's a summary contempt. If it happened out of the courtroom, although it's in front of the judge's eyes, it's indirect contempt. And what would the indirect contempt be? Well, sue in the name of a fictitious plaintiff would be one. To not sign your complaint and then have it brought to your attention and still not sign it, well, that would be indirect contempt. Immediate view and presence are words of limitation and exclude the idea of constructive presence. The immediate view and presence does not extend beyond the range of the vision of the judge, and the term applies only to such contempts that are committed in the face of the court. Of such contempts he may take cognizance of his own knowledge and may proceed to punish summarily such contempts, basing his action entirely on his own knowledge. All other alleged contempts depend solely upon evidence and are inferences from fact, and the foundation for the proceeding to punish, therefore, must be laid by affidavit. If you want to point out that it's a fictitious plaintiff, you have to do it by affidavit. If you want to point out that they didn't sign the complaint, you need to do it by affidavit. To punish contempt is summarily. All necessary facts must be within the personal knowledge of the judge. A judge does not have personal knowledge for purposes of summary contempt if the judge must rely on the testimony or of other persons to establish the case against the contemptor. Right? So how's the judge going to know that that's a fictitious plaintiff? Although he does. How's he going to know? You're going to have to provide evidence. Therefore, it's not direct contempt, it's indirect. You got to provide evidence, you got to give them a frickin' affidavit. No big deal. But you don't give it to the court clerk, and you don't put it in the court file, you don't take it to the court window. You take the damn thing to the court administrator. In Wood, the Michigan Supreme Court held that alleged contemptor's writing words of protest upon a check made out to the court but delivered to the clerk was indirect contempt. Right? So writing on paper is indirect contempt. An initiation of contempt proceedings required the misconduct which is alleged to constitute the contempt be proved to the satisfaction of the court by affidavit. You got to give an affidavit. Because no affidavit had been provided, the court did not have jurisdiction necessary to conduct contempt proceedings. Filing a false pleading may not be summarily punished. Again, filing a false pleading, fraud, may not be summarily punished as contempt. You have to provide an affidavit. It's indirect contempt. Indirect contempt occurs outside the immediate view and presence of the court. Such contempt may not be punished summarily, but only after proof of the facts charged has been made by affidavit, or other method and opportunity has been given to defend per 600.17112. MCR, Michigan Court Rule. MCL is Michigan Compiled Law. MCR is Michigan Court Rule. 3.606 contains the procedural requirements for indirect contempt cases. Let's take a look. What do you need to do? Initiation of proceeding for contempt committed outside immediate view and presence of the court on proper showing of an ex parte motion supported by affidavits. The court shall either. What did it say? Ex parte motion. Ex parte motion doesn't go into the court case. You don't send a copy to the other plaintiff or to the other party. It goes to the judge through the judge's clerk, who is the court administrator. Ex parte motion, supported by affidavits. So you would do an ex parte motion and have an affidavit. The court shall either order the accused person to show cause, this would be by subpoena, at reasonable time specified in the order, why the person should not be punished for the alleged misconduct, such as suing in the name of a fictitious plaintiff. That would be directed against the attorney of record for bringing a court case to court that had a fictitious plaintiff. He brought fraud upon the court. Or, in the case of a traffic ticket, the officer isn't signing with his name. Or there's something wrong with the form. We'll get into that here in a little bit, right? If they don't fix it, it's contempt of court. So either they're going to do a show cause or they're just going to issue a bench warrant for the arrest of the person. Well, right. What could this person do? What could this person do? Authorize bench warrants. Right? So, who are you taking this to? You're going to take it to the court administrator because they can authorize bench warrants. And that's what they're going to do, issue a bench warrant. Writs of habeas corpus. A writ of habeas corpus to bring up a prisoner to testify may be used to bring before the court a person charged with misconduct under this rule. The court may enter an appropriate order for the disposition of the person. Right, so you don't write a habeas corpus, you go ask for one to have the guy brought up to the judge to say, hey, I'm sorry for contempt. Forgive me, please forgive me. Bow your head, ask forgiveness. He doesn't give you forgiveness, well, in God's eyes, he brought the controversy. Right? But while you're there, let's point out the reasons the guy would have been upset enough to get contempt against him, because the other party is a fictitious entity, and you want to have contempt charges brought against them. Bond for appearance, yada yada yada. So some other things, but basically, right, the way it gets started is here. You do an ex parte motion. That's a private. It's a motion between you and the judge, not you and the court. Well, I shouldn't say that. Yeah, you and the court as far as the judicial side of the court, but not you into the administrative side where you need to do a service on the other party. No, this is ex parte, one-sided motion to the court administrator with an affidavit to support. Ex parte motion for a contempt of court hearing. For indirect contempt. Elements of contempt of court. Indirect criminal contempt. Willfully doing of a forbidden act or the willful refusal to comply with an order of the court. Sign your damn complaint. That impairs the authority or impedes the function of the court. Committed outside the immediate view and presence of the court, where the court seeks to punish past misconduct and civil contempt remedies are inappropriate. Prior to the initiation of the proceedings, the court must determine whether civil or criminal contempt proceedings are appropriate, because the defendant charged with criminal contempt is entitled to be notified of the fact when he or she is notified of the charges. Determining whether a hearing is required. After the court determines whether criminal or civil contempt proceedings are appropriate, the court must determine whether contempt was direct or indirect. If the contempt was committed during its sitting and its immediate view in the presence of the court, the contempt is direct, and the court may summarily make finding of contempt and punish its contemptor. If, on the other hand, the court must rely on the testimony of others to establish the contemptuous conduct has occurred, the contempt is indirect and separate hearing must be held on the issue. I keep telling you what you need to do. In all cases of indirect contempt, proper notice of the charges, a reasonable opportunity to prepare a defense or explanation, opportunity to testify and call witnesses are the basic procedural due process requirements. But you're not doing them. That's what the court's going to do, because lawfully only the court can call someone to court. Not a plaintiff. The court calls you to court. Because you've gone there and given them probable cause why the other party should show up in court for a show cause hearing, why they shouldn't be held in contempt of court or charged with a felony or whatever it is. What constitutes a reasonable opportunity to prepare a defense must be viewed in the context of the entire situation. Yeah, yada, yada, yada. Okay. Procedural requirements that differ depending on whether a procedure is civil or criminal. In case of criminal contempt, the contemptor is entitled to procedural protections. Defendant in a criminal case, equal gravity, would be entitled. Criminal contempt must be proven beyond a reasonable doubt. Civil contempt, standard of proof is unclear. Criminal contempt, cases the alleged contemptor is presumed innocent and must not be compelled to testify against himself. Civil contempt proceedings and criminal contempt proceedings are not deemed serious. The contemptor has no right to a jury trial. A hearing must be conducted, this is indirect, when the contempt is indirect. So that hearing is the show cause hearing, which will be initiated by a subpoena being issued by the court administrator. When any contempt is committed other than in the immediate view and presence of the court may punish it by fine or imprisonment, or both, after proof of the facts charged has been made by affidavits. Due process requires that contempt is allegedly committed outside the court's presence, the accused given notice, the charges against him or her, a reasonable time to prepare, have a hearing, opportunity to offer a defense, yada, yada, yada. But again, it's the court that's going to notice the respondent that he needs to come in and answer for the contempt charge. In direct contempt cases, the judge who witnessed the contemptuous conduct initiates the proceedings. There is no attorney for the complainant. In cases of indirect contempt, the person who initiates the proceedings differs depending on whether the proceedings are civil or criminal. In some cases, the procedures for initiating the action are set forth in statutes of the court rule. When such procedures are not provided, however, courts must look to case precedent, some federal, for guidance. Specific indirect contempt proceedings. In the following circumstances, initiation and prosecution of contempt is governed by a statute of the court rule. A prosecuting attorney, the attorney general, or citizen may bring action to abate a nuisance. A friend of the court or an aggrieved party may institute action to enforce orders or judgments in domestic relations cases. In criminal contempt proceedings for violations of personal protection orders, a prosecuting attorney may prosecute unless the petitioner retains his or her own attorney. Unspecified indirect contempt proceedings for contempt committed outside the immediate view and presence of the court on proper showing of ex parte motion supported by affidavits, the court shall either order the accused person to show a reasonable time specified in the order why that person should not be punished for the alleged misconduct, or issue a bench warrant for the arrest of the person. Either or. A prosecutor need not initiate proceedings for or prosecute a claim for indirect criminal contempt. It is manifest that the Michigan court rules contemplate that a private party may initiate and prosecute a motion to hold an opposing party in criminal contempt. It is manifest that the Michigan court rules contemplate that a private party may initiate and prosecute a motion to hold the opposing party in criminal contempt. They want you to do it. They need you to do it. The Court of Appeal stated that indirect contempt proceedings must be initiated through an ex parte motion supported by affidavit of facts showing the alleged contemptuous conduct. The Court of Appeals reversed the trial court's contempt order in the case because a contempt proceeding was not initiated properly. A proceeding to punish constructive contempt is instituted by ex parte motion, made by the friend of the court or by interested and proper party. The motion may not be made by a judge. Accordingly, the private party or their attorney may initiate the prosecute an indirect criminal contempt proceeding. However, if an indirect criminal contempt proceeding has not been initiated by a private party or their county or their attorney, then a judge must appoint a prosecutor to initiate an indirect contempt proceeding. Initiation, affidavit, or other method. In the case of indirect contempt or indirect contempt cases where the court has deferred a hearing on the alleged contempt, the court may punish the contemptor only after proof the facts charged have been made by affidavit or other method and an opportunity has been given to defend. This MCR 3606 again contains the requirements. Relevant parts. For the contempt committed outside the immediate view of the presence of the court on proper showing of an ex parte motion supported by affidavits, the court shall either order the accused to show cause, subpoena, issue a bench warrant, handcuffs. Thus, indirect and deferred contempt proceedings are usually initiated by ex parte motion supported by an affidavit containing the facts upon which the contempt charges are based. The court may then issue either a show cause order or a bench warrant. There's only two things it can do. The alleged contemptor must be informed by order to show cause or a bench warrant. Show cause or given bracelets, notice, statutes, and court rules specify certain contemptuous conduct may also replace these general requirements. See Chapter 5 more examples. I didn't go look at that. Other method. This held trial court could take judicial notice of its own records to satisfy the requirements of 600.1711 that proceedings must be initiated by affidavit or other method. Right, so you tell the court to take judicial notice of its own records. That you're being charged for a crime, but there's no complainant, there's no sworn complaint. Well, if there's no sworn complaint, but there's complainant witnesses, then the witnesses must be committing perjury because there's nobody ever put in a complaint. Maybe initiated a non-written complaint or petition stating sufficient foundation of facts on which to base the finding of contempt. Okay, so you get it. You get the idea, right? You got to do an ex parte motion for a contempt of court hearing based on the evidence supplied in an affidavit and any other evidence you might have, like a certificate from the Secretary of State that says the plaintiff doesn't exist. Following a hearing on ex parte motion, the motion and supporting affidavits must be personally served on the alleged contemptor in every case, regardless of whether the show cause or bench warrant is subsequently issued. But again, I don't believe we do this. This is what the court does. Only the court can call somebody to court. The judge who presided over the proceedings in the context of which the indirect contemptuous conduct occurred should preside over the contempt proceedings. That same judge you're in is the guy who's supposed to be over the contempt proceedings. Don't argue with it. The constitutional right to jury trial applies only to serious criminal contempt. In Michigan, criminal contempt is petty rather than serious if the penalty does not exceed 6 months imprisonment. Okay, so if it's less than 6 months, they're not going to get a jury trial, and somewhere earlier it said 93 days or something like that. So, right, they're not going to get a jury trial. It's going to be a judge making a decision. This is quick. And the rules of evidence apply. So we'd have to pay attention to rules of evidence. And one of the rules of evidence is to make your evidence foolproof evidence, like if you do an affidavit or an acknowledgement, and I think this is Rule 902 in the federal rules of evidence. I don't know what they are in the state rules, but you do an affidavit and you get the notary to put her seal on it, and then you need to go get the notary's certificate of authority to have that seal. That makes it foolproof evidence. You get it authenticated, basically. Now, we went to the county clerk to have this done, and they did it on a piece of paper and did their thing. But I'm not so sure, again, that you wouldn't go. I would say with everything, you go to the court administrator first and ask them and say, I need to have an authentication of a notary seal. Who does that? The reason is the court administrator is the chief executive officer of the entire court. They know what everybody's job is. Right? They had better be able to tell you who you go see to have something done. They're the CEO. So basically, Rule 219 is motion practice, right? So one of the things you need to do is an ex parte motion, an application to the court for an order. That's what we're doing. That's what a motion is. An application to the court for an order. It's sort of like doing, when you think about it, especially when it's a ex parte, this is like doing a praecipe. Right? I'm trying to get a particular order done by praecipe. Some places they have praecipes you use. This way you're going to do it with a motion. So anyways, it must be in writing, state the particular the grounds or authority from which it is based, state the relief and order sought, and signed by the party or attorney as provided by yada yada yada. A motion and notice of the hearing may be made combined in the same document. Form of affidavit. If the affidavit is filed in support of or in opposition to a motion, it must be made on personal knowledge, state the particular facts admissible as evidence, establish or denying grounds stated in the motion, show affirmatively that the affiant, if sworn as a witness, can testify competently to the facts stated in the affidavit. Oh yeah, man, the plaintiff didn't sign his complaint. When any contempt is committed other than in the immediate view and presence of the court may punish it by fine or imprisonment, or both, after proof of facts charged have been made by affidavit or other method and opportunity has been given to defend. Okay. You got the idea, right? Ex parte motion with an affidavit for contempt of court. So let's look at some examples. Arizona Criminal Code. Complaint. A complaint may be laid before a magistrate. Complaint need not be verified. Complaints stating misdemeanor charges laid before a magistrate under the provisions or filed with the magistrate under the provisions need not be sworn to if they contain a form of certification by the attesting officer in substance as follows. I hereby certify that I have reasonable grounds to believe and do believe that the person cited herein committed the offense described herein contrary to law. Alright, so if the complaint form they're using has those words on it, they don't need to go lay it before a magistrate and swear to it. But this is the one that they use. Again, this is stuff we've covered before. This is nothing new, but it's good to go through. Because this is, anybody on your this Arizona traffic ticket and complaint. If you got a traffic ticket, look at the damn top of it, see what the name of it is, Google it, and start looking for information on it. Okay? So, Arizona traffic ticket and complaint. And when you look at what it says here, how do I make this bigger? Zoom. Okay, first thing. Last thing. See where it says officer, right? He had better put his signature here and his number. Right? I believe this is where he's supposed to sign it. But his name isn't an initial, right? You wouldn't get away with that. He needs to sign his complaint. Now this says, I certify upon reasonable grounds I believe the defendant committed the above violations. I hereby certify that I have reasonable grounds to believe that, and do believe that the person cited herein committed yada yada. I certify upon reasonable grounds the above violations, and I have served a copy of the complaint upon the defendant committed the offense described herein contrary to law. So this, I hereby certify that I have reasonable grounds to believe and do believe that the person cited herein committed the offenses described herein contrary to law, is nothing like what it says on the form. Then, that didn't say anything about serving the paperwork on the complaint on the defendant. I certify that upon reasonable grounds I believe the defendant committed the above violations. Now there's a law that goes along with this. This is like a uniform or universal ticket. And in the law it says they can change the wording on this, but they need to be careful because it could be that they're going to make it invalid. And I think that's exactly what they did right here. That this right here just made it invalid. Now, the reason that I believe they haven't sworn to the complaint is really simple. When Bob in Arizona had a problem and we were bringing this up, that, well, they didn't swear to their complaint, the prosecutor and attorney says, well, we don't need to swear to the complaint. Right? He pretty much admitted they're not swearing to the complaint. Handcuffed John in Virginia was told by the district court clerk, or one of the clerks there, said, well, we don't have any sworn complaints. Nobody swears to anything. Well, if it's a criminal matter, they need to swear to their complaint. That's the whole point. That's contempt of court, not to swear to the complaint. If they won't fix it, they've brought fraud in the court. That's contempt. We'll let them get them for the rest of the stuff. A false certification under the provisions of this subsection shall constitute perjury. Well, I'm saying that this is a false certification. Right? It's not like this one. I hereby certify that I have reasonable grounds to believe and do believe that the person cited herein committed the offenses described herein contrary to law. Shall constitute perjury if it's a false certification. Arrest without warrant. A person arrested without warrant shall, without necessary delay, be taken before the nearest and most accessible magistrate in the county, and complaint shall be made before the magistrate. That's what they're supposed to do. However, shall not apply when the person making the arrest is a peace officer. So, if he's a peace officer, it means he's taken the proper oath. You want to see his oath? I haven't seen that yet. And decide to so by what authority did he bring this charge? Is he a peace officer? And decide to proceed under the provisions of 133903, which says, arrested for a misdemeanor offense, arresting officer may release the arrested person from custody in lieu of taking the person to law enforcement facility. So what this is saying is you are arrested whenever they give you a complaint. Whether they let you leave the scene or not, you've been arrested. You're under arrest. You've been released on your own recognizance. At any time after taking the person arrested of the misdemeanor offense or a petty offense to a law enforcement facility, the arresting officer, instead of taking the person to the magistrate, may release the person from further custody by use of the procedure prescribed in this section. So they can drive you to the law enforcement facility and go through the whole spiel and then release you. You're still been arrested and you haven't gone before a magistrate, and the peace officer, if he is one, hasn't sworn to his complaint. If a person is arrested for a misdemeanor offense or a petty offense and the offense is listed in some section, shall not be released unless they're fingerprinted. In any case in which a person is arrested for a misdemeanor offense or a petty offense, and the arresting officer may prepare and quadruple it, a written notice to appear and a complaint containing the name and address of the person, the offense charged, and the time and place of when the person is in court provided. Again, if they give you this damn piece of paper You've been arrested. You're under arrest as soon as they give you this paper. All right, so I mean, they got a few things they got to put in, but the name and address of the person, the offense charged, and the time and place in which, so you want to make sure all that stuff's been put in. Time specified in the notice to appear is at least 5 days after arrest. Place specified in the notice shall be the court specified in whatever. See, this sounds like there's two pieces of paper. There's a notice to appear, and there's a complaint. Now, when you look at this piece of paper, this says it's a traffic ticket and complaint. Original complaint. This is a complaint. Right? But they're going to have you someplace here. Without admitting guilt, I promise to appear. And without admitting responsibility, I acknowledge receipt of this complaint. If they check the top one, without admitting guilt, I promise to appear, you've just made a promise to appear. If you don't appear, you broke your promise. And now they can issue a warrant for your arrest for not appearing, for breaking your promise. If the arrested person, in order to secure release, as provided in a section, shall give his written promise to appear by signing at least one copy of the written notice and complaint prepared by the arresting officer, the arrestor shall deliver a copy of the notice and complaint to the person promising to appear. And again, that's right here. Check that box where it says criminal. Without admitting guilt, I promise to appear as directed hereon. Or you don't need to do any of them. If you just sign this box, you're doing both of these. You're without admitting guilt, I promise to appear, and without admitting responsibility, I acknowledge receipt of the complaint. If you don't cross those out, I guess they apply because they're all within the same area. What's that box got to do? That box isn't even on the paper. The officer, as soon as practical, shall deliver the original notice and complaint to the magistrate specified. Thereupon, the magistrate shall promptly file the notice and complaint and enter it into the docket of the court. The Arizona traffic ticket and complaint may be utilized not only for the purposes provided by Arizona Supreme Court rule, but to satisfy the requirements of this section. When a person is given his written notice, his written promise to appear in court upon designated date pursuant to the section and thereafter fails to appear, personally or by counsel, on or before the date, the court clerk or other court staff shall file a complaint in writing under oath setting forth the offense of knowingly violating a written promise to appear in court in accordance with this section. So let's think about this. Right? You sign your name, this thing goes in. This is a criminal offense, and so it should go to the judicial side of the court. When you go into court, you're going to go into the administrative side of the court. You're not going to go to the judicial side of the court, so you're not going to appear before the proper court. It's my opinion. Right? We're not when we walk in the door that they want us to walk into. For instance, when Bob had this traffic ticket, it came to the first time he had to go to court. Well, they met him out in the hallway, and they yada, 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 talk. And he left. He never went into court, never saw the judge, so really he never appeared. Now, I don't know if they issued a warrant at that time or not, but they certainly could have. Or it could be, again, if you're walking into the administrative side of the court and not the judicial side, then you didn't appear in the side where the controversy is, because all the judicial power of the court can be used for is to settle controversies between people or person. If there is no controversy, there's nothing there's no judicial action that the court can take. It's just administrative. Just setting the record straight to show whose property something is, because no one's contesting it. We're just going to go ahead now and change the record. That's what is happening in those property hearings. just determining the rights, title, and interest of the property, and because it's an in rem hearing, that by law means there is no controversy. So it doesn't matter you're over there squawking and yakking, you're just a belligerent, basically. You've already agreed by coming here that there isn't a controversy. If you had a controversy, why don't you take it to the judicial side and say, hey, I have a controversy with the plaintiff or his attorney. So if you do your promise to appear and you don't, well, then you failed to appear, and boom. And if you fail to appear to the judicial side of the court because you went to the administrative side of the court, that could be enough to get you a frickin' misdemeanor for failure to appear. But what's going on here? Well, they're simulating a legal process by falsely purporting to be an order or other document that simulates a civil or criminal process. Alright, so this says it's a complaint, but if it's just a promise to appear and it says it's a complaint, then it's a simulated legal process, because this blurb here doesn't cut mustard to be what was necessary for a complaint certification. So it isn't a complaint unless the officer goes before the magistrate and swears it as a complaint. And he didn't do that, so really all it is a promise to appear, hiding under a document that's supposed to be a complaint. And guess what that is? That's called a simulated legal process. Falsely purporting to be an order or other document that simulates civil or criminal process. That'd be perjury. It's a class 2 misdemeanor. Right? It's perjury to have a false certification. That was way up here, remember? Perjury. False certification on the provision of subsection A of this section shall constitute perjury. There's a false certification right there. If they want to call that a complaint and they using that, it's a false certification. Right? Is it or not? Hell, I don't know. That's why you're going to the court administrator. You're going to put it on an affidavit and make him make a frickin' decision. Right? They know what the law is. If you're right, they're going to say you got probable cause, and they're going to have to do something with it. So, if not, if they're not going to, then you're going to take them to the court of claims. If they can't tell you that that's okay, well, then I want you to put that on. I want your testimony that that's okay, that this incorrect looking certification is correct. So it's not a simulated legal process. Okay. Give me your testimony. All right, so that was Arizona. And I just want to show Michigan's real quick. Where was Michigan's? That's what Michigan's look like. And good friend Tom got one of these recently. And what did it say? When he got this, he said that this printed off the machine inside the cop car. And when he got his copy, the cop didn't sign anything. Right? It printed out officer's name, and it was an initial and a last name, and that's what was here, an initial and a last name, and neither of those are your name. You don't get to use initials. Right? If you went to this officer's ID number and looked at his file and got his name there, it would have his given name. This has to be his given name, and he has to sign the damn thing. And the guy never put pen to paper. So he did not sign his complaint. All right, that's contempt of court. You're simulating the legal process. Where was that one for Michigan? Issuance of process. Magistrate may issue process. Now, why is that important? Just real quick. I got so many of these things. I just wanted to pull little pieces out because they're It's good reinforcement. Let's look at this. Court administrator. An officer of the judicial system who performs administrative and clerical duties essential to the proper operation of business of the court, such as tracking trial dates, keeping records. The record. So order the record, entering judgments, and issuing process. And that's what we're talking about here in this Code of Criminal Procedure. Issue of process. Court administrators can do it. So when it says a magistrate may issue process, you can just say, well, a court administrator may issue process. The applicant signs the complaint. A complaint for an arrest warrant may be made by any electronic or electromagnetic means of communication if all the following occurs. Prosecuting attorney authorizes the issuance of the warrant. Authorization must consist of the authorization. So first of all, the prosecuting attorney has to agree. The judge orally administers an oath to the applicant for the arrest warrant, who submits the complaint and signs the complaint. Got to do those things. The person in the department receiving electronically or electromagnetically issued arrest warrant shall receive proof that the issuing judge has signed the warrant before the warrant is executed. Proof that the issuing judge has signed the warrant may consist of electronically or electromagnetically transmitted facsimile of the signed warrant. And what Tom said is, when he got his copy of this thing here, there wasn't anything signed by anybody. It was printed out, but it wasn't a signature. The guy never put pen to paper. It didn't have his name. I don't think it cuts the mustard. Complaint. A magistrate shall issue a warrant upon presentation of a... So this is the good thing. Now, the court administrator shall issue a warrant upon presentation of a proper complaint, because you can do a complaint alleging the commission of offense and finding of reasonable cause to believe the individual accused in the complaint committed the offense. So you could go to the penal code of your state and say, okay, they're doing this, and pull it out of the penal code and put yourself together a complaint. Some evidence, probable cause, boom, they got to issue a warrant. And like the judge told me, it's not that you're not correct, I'm just not inclined to issue any warrants. And a week later, after I got out of jail, I got a letter from her, and I had these 3 different complaints in, and I had not given any just cause. All right? I hadn't given a reasonable cause. I hadn't sworn to my complaint. Is number one problem. I hadn't sworn to it. The complaint shall be sworn before a magistrate or a clerk. I hadn't done that. I thought they could call me and I could just give them take it over the phone. I'd read that someplace. I didn't point it out, though, unfortunately. It doesn't matter. I know better. A court administrator shall issue a warrant upon presentation of a proper complaint. I get it. Thank you. Factual allegations of the complaint contained in the complaint. Right? This is what reasonable cause is. Factual allegations. The complainant's sworn testimony. The complainant's affidavit, which is really your sworn testimony. Well, I guess that's the facts that you believe. Any supplemental sworn testimony. A magistrate may require sworn testimony of the complainant or other individuals. Supplemental affidavit may be sworn to before an individual authorized by law to administer oaths. Factual allegations contained in the complaint, testimony, or affidavit may be based upon personal knowledge, information, and belief, or both. You just got to be close. Magistrate shall not refuse to accept a complaint alleging a crime was committed which a victim is a vulnerable adult. A vulnerable adult on the grounds that the complaint is signed upon information and belief by an individual other than of the victim. And it says the vulnerable adult means is defined here, yada yada yada. I'm going to say I could stretch that and say, look, you got somebody incarcerated in jail. That's a pretty much vulnerable adult. I should be able to put in a complaint for him. A warrant issued pursuant to Section 1A shall recite the substance of the accusation contained in the complaint. Take that person without necessary delay before the magistrate. Issuing warrant or endorsing complaint. If accused in custody upon arrest without warrant, finding of reasonable cause, endorsement of the complaint and warrant. If the accused is in custody upon an arrest without a warrant, like they've stopped you on the side of the road, a magistrate, upon finding reasonable cause, as provided in Section 1A, shall do either of the following: issue a warrant as provided, endorse upon the complaint a finding of reasonable cause, and direction to take the accused before a magistrate of the judicial district in which the offense is charged. As endorsed pursuant to something, the complainant shall constitute both complaint and warrant. Complaint signed by a peace officer. Statement making material false statement in complaint as perjury. Penalty, contempt of court. For the purposes of, was committed in the signing officer's presence. Well, again, where the heck is it at? Complainant signature and receipt. Signing officer, he's got to sign it. Or that was committed under the circumstances permitting an officer to issue a citation under sections, some other sections, yada, yada, yada. And if the complaint contains the following statement immediately above the date and signature of the officer, I declare under penalty of perjury that the statements above are true to the best of my information, knowledge, and belief. A peace officer who, knowing the statement is false, makes a materially false statement in complaint signed under subsection 1 is guilty of perjury, a felony punished by imprisonment for no more than 15 years, and in addition is in contempt of court. Okay, well, what if he doesn't sign it? Well, then it's still perjury because they put it in the court case, and now he won't sign his complaint? Just did that. Let's see here. The complaint contains the following statement immediately above the date and signature of the officer. Okay, there's the immediately above. I declare under penalty of perjury. So those are the correct words. There's the signature and there's the date. He needs to sign the frickin' form. Arrest without warrant, arraignment by a magistrate or family division of circuit court. That's interesting. Why would they take you to family division? Family division has jurisdiction over juveniles and dependents. As we learned last week, that's the same as saying the judge of probate. It's the probate judge. We got a probate court, but that ain't the probate judge. In the family division is the probate court that they talk about in the one court of justice, in which there is a Supreme Court, an appeals court, a trial court of general jurisdiction, and a probate court. One probate court. If a person is arrested without warrant in any of the following cases, the arrested person shall, without unnecessary delay, be arraigned by a magistrate in the nearest and most accessible, yada, yada, yada. In any of the following cases. Okay, moving violation that caused death, operating motor vehicle while intoxicated, reckless driving on a highway. This one is interesting, this intoxicated one. I had to go back and look. They had like 3 different levels of blood levels in there. It's like, well, which one are you picking from? If the arresting officer otherwise satisfactorily determines the identity of the person and practically and subsequently apprehension of the person fails to Voluntarily appear before designated magistrate or the family division of the circuit court as directed. Before the designated magistrate, so they're supposed to tell you what magistrate to go before, or you go to the family division of the circuit court. Right? That's where you're supposed to appear. To the designated magistrate or to the family division of the circuit court. The officer may release the person from custody with instructions to appear in court, given in the form of a citation as described in section 728, which is the one we've been looking at. There's one here. Uniform law citation. Right? But you're still under arrest. This is the point, right? So you've been unlawfully arrested. You're unlawfully arrested, right? And that's a penal code violation. And it's contempt of court. And, right? I think you need to go see the court administrator. A citation means a complaint or a notice. The original, which the complaint or notice, yada yada, file with the court. Now the thing is, when you look at this thing, they got a place on it here that's going to say, if he checks the box, I personally served a copy of the complaint upon the defendant. Right? If he checks the box, it's a complaint. Otherwise, it's a notice. Okay, well, what's the difference between a complaint and a notice? If it's just a notice, they still haven't filed a complaint against me. Somebody needs to swear to this. Or there's no sworn complaint. It's just a notice. It's like that notice of lis pendens. It doesn't mean anything by itself. And then the first copy goes here, second copy goes there. Yada, yada. You can use it for things other than moving violations. There's that line again that they need to put on there. When a person is arrested without a warrant, act punishable as a misdemeanor. Not referred to in these sections. Punishable as a misdemeanor under conditions not referred to in 617, 619. Okay, so if it wasn't a serious impairment, and you did the duties of the driver and arrest without warrant, arraignment by magistrate, the arresting officer shall prepare as soon as possible, completely as possible, an original and 3 copies of a written citation to appear in court before a magistrate or probate court within the county. Right? This time I said probate court. Before it's been saying the family court. Right, I think I said it up here. Oh, where's the last place it said it? Oh well. Well, here's another. What is this thing here? A guaranteed appearance certificate means a card or certificate containing a printed statement that a surety company authorized to do business in the state guarantees the appearance of the person whose signature appears on the card or certificate, and the company, if the person fails to appear in court at the time of trial or sentencing, or to pay any fines or costs imposed in this act, will pay any fine, cost, bond, forfeiture imposed on the person in the total amount not to exceed $200. So you can have one of these guaranteed appearance certificates from a surety company who's going to guarantee that you show up, so they don't haul your ass off to jail. This was supposed to be for a non-resident. I think that's what it said. Arrest without warrant, arraignment by magistrate or family division of circuit court. And then talk about going to a probate court here. Okay, well, that's pretty much it. So, what was all this for? Well, to point out that number one, if you have a foreclosure and you have a lis pendens, even if you don't have a lis pendens, let's say you have a court case going on of any kind, go to the court administrator and say you would like to order a copy of the record for this court case, because you do not have the whole court case. I've had numerous people tell me in the last 3.5 years I've been doing this that they've been to court and talking to the judge, everything seems like it's going their way, or not going their way, but at least they're not being railroaded yet. And they'll talk about not having been given some kind of paper or whatever. The judge will be going through his stuff and say, "Oh, you didn't get a copy of this," and he'll hold it up in the air. The guy would say no, and so the judge would tell the attorney, "We'll give him a copy of this." Right? The point is, when they look at the judge's folder, it's much thicker than theirs, and they've gotten everything they can from the court clerk that the court clerk says is in the file, but the judge's is thicker. Who's putting the judge's file together? The court administrator. Get it from the court administrator. The other thing is, the court administrator over the probate court, not the fake probate court, I don't believe, but the one that's part of the one court of justice, or however your system is set up, and give them your all capital letter name and tell them you want a copy of the record. It's your property. Right? Don't run away from all caps. He's your property. I want a copy of the record. I want to determine the rights, title, and interest to this property. It's my property. Now, all this has to do with the fact that we're not citizens, so we don't have full rights of citizenship, which would be access to our estate. And how do they do this? Because we didn't register within the Ward Republic, the smallest self-governing territory of land. Looks like it's an election district. Could be a school district. Now, when I was thinking school district a couple weeks ago, I was thinking of the school district that has maybe 6 or 7 schools and a high school, and it says school district, and they got a superintendent, and yada, yada, yada. And it still could be that. However, every school has a district because the kids within a certain territory go to that school. So my school district, looking at it that way, is a school over here called Lakeview Elementary School. I would be within that school district. What I don't know yet is what election precinct I'm in, and that's what I'm going to find out next week. Because when you want to vote in the precinct, you need to go to the precinct, or you need to go to the election board and sign an affidavit. Now, how many people who've ever voted had to sign an affidavit to vote? Nobody. You just go down and register to vote. We're not registering to vote. We're registering to be an elector, and you need to sign an affidavit. But that's its own video coming up soon. I wanted to get this one done because start using the court administrator. If you got a court case, go to the court administrator, order a copy of the record, get the entire copy of the record. If they haven't signed the complaint, then take an affidavit to them and say, "Hey, I'm not really sure I'll do an ex parte motion. Can you help me with that? Because there's contempt of court going on. The plaintiff didn't sign his complaint. The plaintiff doesn't exist. It's a fictitious plaintiff." All right, let's see what they say. But I can tell you what they told Xavier. They said, "Yeah, if you want a copy of the record, you're going to have to go to the court where it happened and order a copy of the record." And he specifically said the certificate of pendency and the record for the foreclosure. To the court administrator, they didn't bat an eye and confess and avoid away. They do when you go to the frickin' window like they don't know what you're talking about. The court administrator doesn't have that out. They are the executive officer of the court. They need to know what everybody's job is in the court. So, we're going to find a way to use that. Okay, we'll leave it there. See y'all. Take care.